Hello and welcome once again to yet another episode of A Question of Law. This is Citi TV's legal education program, and on this show we seek to break down the law as regards the things we hear in the media, things that we go through in our daily lives, and so on and so forth. We want to stay in touch with you. So as you're watching, if you're watching on any of our streams, kindly use the hashtag A Question of Law for us to hear what you're thinking. The WhatsApp line is 0550-585832. My name is David Kwekusichi. Now, we're going to take a quick break. When I come back, I'm going to introduce my guest to you, and we will get right into the conversations for today. All right, welcome back. Now, my guests are in studio. We are ready to go. The conversations are hot, stuff in current affairs, and you want to get to find out what's going to happen today. I have joining me on the set, Selim, I don't know who is a private legal practitioner, as well as Albert Kwashiga. He's also a private legal practitioner, but he's also a law lecturer with the School of Law at UPSA. Gentlemen, you're welcome.
Thank you.
Thank you.
How have you been?
It's been good.
Yeah?
Yes. There's never a dull moment
There's
in
never a
Ghana.
dull moment in Ghana.
In Ghana, there's always something to talk about.
Always something to talk about.
Yes.
Yeah.
How have you been?
Pretty good. Weather has been a bit funny, so it's kind of, there seems to be some kind of a bug in the air or something.
Looks like,
yeah. But we're good otherwise. Someone was in the country, out of the country, come back into the country. We're dealing with Aisha Huang and the issues of repatriation versus deportation. And, listen, let me tell you where I stand on this whole thing. I also have, there's another word. So there's repatriation, deportation. I'm saying prosecution. Why are we, why are we skirting around, all the issues? But let's just talk about the difference between repatriation and deportation, because in the English dictionary, there are vastly different issues. What does the law say?
Well, interesting. The matter of Aisha Huang has been very topical lately, and partly due to our own inaction and this thing about Ghanaians not wanting to solve problems conclusively. We just touch and go, and the thing comes back to haunt us. The political will often to deal with problems like this is absent, and that is why we keep going around in circles. So you can imagine that in sometime 2017, this matter came up. We dealt with it a certain way. We didn't conclusively deal with it. We spent a lot of time like we are doing around that time, and then we just let it go a certain way. Few years down the line, here we are again, spending a lot of time, resource on this particular person. And this is just one person. And you can imagine what the case would be if we had 3, 4, 5 of similar instances.
Yeah.
The whole nation appears to have come to a halt just because of one non-national, And my own views about how, we have sought to put everything around illegal mining on this woman. I don't think she is that powerful in the space of illegal mining. Of course, she has other things she does. If you mute her or you nip her in the bud, I'm not sure the fight against Galamsey will end or will see any significant improvement. So I think it's a way of hanging everything around her neck and crucifying her. She has to be prosecuted. She has flouted the law. But I'm also guarding against the temptation of thinking that once you deal with her, everything else will fall in line. That would be a myth. In fact, when she supposedly left the country in 2017, Galamsey was still, a very profitable trade, and people were involved. We need to find those people and deal with them and stop, blowing Aisha Huang out of proportion. We must deal with her because she has offended, so we must deal with her. I'm not saying we should leave her. We must deal with her decisively and conclusively and let the law take its course. And let's focus on other things. We know what to do to win this fight. We know. And almost every big person in Ghana has some connection to illegal mining or galamsey of a kind, we need to have the political will and go after those people and stop thinking that once we cage Aisha Huang, everything else will be fine.
Yeah.
Before I get to the issue about deportation and repatriation, we know she was in court on Wednesday, and the court did not grant her bail or did not admit her to bail, like we suspected before. Given the nature of the matter and all of that, it wasn't in anybody's interest for her to be granted bail. In fact, it was not even in her own interest to be admitted to bail. So the court, we understand for public interest reasons, decided not to grant her bail.
But who is going to come for her if she's granted bail?
Well, we don't know. And this is somebody who is very slippery. She could run away. I'm sure she's of flight risk. And one of the key reasons a court will give, for example, for not admitting somebody to bail is that the person is a flight risk. The person may not be available to attend trial. And in this case, she is not Ghanaian. So she could run away and resurface a few years later. We don't want that. So I think it is not out of place for the court to deny her bail. So I think it's fine. There were 3 of them, and they came on certain charges, which I think we'll go into. But I think the prosecution must continue. Okay. But we do not have to think that once we deal with everything else will fall in place. I don't think so. In any case, she has ties with certain people or certain powerful people in our society, whether traditional leaders, opinion leaders, government officials, etc. She has ties with very powerful people who know her modus operandi. And those people must also be identified and dealt with. That's when we will know that we are taking this fight, a bit more seriously. Yeah. Deportation and repatriation. I think deportation is a stricter undertaking than repatriation. Indeed, the Immigration Act of Ghana, Part 3 of it, Section 35, deals with the matter of deportation. Okay. And it says, or it tells who can be deported. In fact, it's a foreign national who can be deported. So it says a foreign national is liable to deportation if, one, a court recommendation for his deportation, and his also means, her, he also means a she. Yeah. For his deportation is effective under subsection 2 of this section. B, he has been found by a court to be destitute or without means of support, or to be of unsound mind or mentally handicapped, which means you cannot come from your country and become a nuisance to us. Yeah. If you fall within that, the court can pronounce or can say that you should be deported. C, he is a prohibited immigrant. I don't know where
persona non grata.
Yeah, I don't know where Aisha Huang will fall. He is a prohibited immigrant. He is in Ghana without a valid permit, or any of the conditions on which his permit was granted has been broken, or his presence in Ghana is, in the opinion of the minister, not conducive to public good. So I see C, D, and E as possible grounds under which a court, for example, could make an order for a person like Aisha Huang to be deported. 2, a recommendation for deportation is effective if it is made by a court upon conviction for an offense punishable by a term of imprisonment exceeding 3 months, with or without a fine. And on appeal against the conviction, the appellate court has upheld the recommendation, or no appeal has been filed, etc., etc. So a high court can do that, and a inferior court can do that, but it has to be approved by the Chief Justice. So where a court makes a finding under paragraph B of subsection 1, the court shall report the findings in writing to the minister. So this presupposes that deportation often carries a higher, it's higher in terms of ranking.
So in a sense, deportation is like an expulsion. You are literally expelling the person from the country.
That is what it is actually. The court orders that you leave the country. So it's higher. Yeah. In terms of repatriation, we see that quite often. It is a bit lower in terms of the pecking order compared to deportation. The immigration service on its own can repatriate people.
Yeah.
I think so. That's my view.
No, but
so
that's for example, when the Liberians were going back home, it was a repatriation.
Exactly. So, for example, we see these Nigerians and all these guys begging around the place. If the immigration service or system thinks that these people are not supposed to be here, they can be repatriated. That is not deportation. They can, on their own, move them back to where they came from or their country. All right. The thing about deportation is that it's so the deportation must come with a deportation order. Even in repatriation, there should be a repatriation order. So Section 36 deals with the deportation order. So the minister, in this case, the Minister for the Interior, may by executive instrument order the deportation of any person liable to deportation. The order may be made subject to such conditions as the minister may impose. A deportation order may include the dependence of a person to be deported when the minister so directs. So, in terms of such conditions,
the minister is the Interior Minister.
The Interior Minister. The order may be made subject to such conditions as the minister may impose. So, my thinking and understanding of this particular provision is that the minister, as he pleases, of course, in accordance with law, may decide that because of the very nature of this deportee, let's do ABC, or let's escort him, or let's handcuff him, or let's do this. You know, so that we know for sure that this person is being delivered to their people. And often in deportation matters, and even in some cases of repatriation, there is often an escort. And you have to ensure that you hand over that person to the immigration service or to the officials of the other side. We do not know if that happened in the case of Aisha Huang. All we know is that, you know, she was put on a flight, an Ethiopian airline flight, which terminated in Addis Ababa. We don't know how she got away or she got out of Addis Ababa.
And where to.
So, of course, we've also heard the argument that she could have been on the flight, she could have gotten to Addis Ababa, she could have rerouted her way to somewhere else. So perhaps she didn't even go to China at all. We have not been provided any information to the contrary. We don't know. So I think it behoves duty bearers to now tell us that indeed they monitored her, they followed her up, and she was indeed delivered to the Chinese officials. And if she was deported, then in as much as far as the deportation order still remained in force, then she had no business coming to Ghana. We don't have all the pieces put together yet. Information is very scanty. No wonder the president himself, you know, in that interview was not sure what it was and was looking around for answer or for information from the people around him. And no wonder the information ministers have pains to try to explain what the president meant, etc. The information, unfortunately, you know, and quite, you know, in a disappointing fashion, is not together. I don't know why the immigration service has not been able to put this together. And I don't know why, as a nation, we are in this right now. So in essence, I would say that repatriation is a bit lower than deportation. Deportation is a bit
as severe.
Not as severe. Deportation carries a lot more severity than deportation, even though in the final analysis, both will require that you are moved from one country to the other.
Very well. But I think Selom has dealt with this in a lot of ways. So let me begin by saying that, you know, whether you are a foreign national or you are a Ghanaian citizen, when you flout the laws, I mean, and it's criminal, you'll be taken through a criminal process. There's no two ways about it. And the punishment will not be lesser because you are Ghanaian, and it will not be more because you are a foreigner. You probably get the same things depending on the judge's discretion within the limits he or she has. And so I am very concerned about the fuss about the arrest of Aisha Huang and her prosecution and all that. You see, if we are not careful, we might be denying Aisha Huang all the rights she deserves as, you know, a foreign national in our country.
In what sense?
Now, in the sense that I've heard the president comment on this matter, and I've heard the president saying that he's going to give the Attorney General all the support in the prosecution of Aisha Huang. I do not know the extent of, you know, support the president is going to give, but I think the AG has been prosecuting criminals for some time, and the AG knows what to do. And so to make a public statement that you will give him all the support, it's as if the entire state apparatus is descending on Aisha Huang. I've also heard that Attorney General call on the judiciary to give its support in the prosecution of, Aisha Huang. And if you listen to the response by Nkrabea Fadate, who is the lawyer for Aisha Huang, this afternoon about the denial of bail, he alluded to some of these matters. And for me, it's beginning to look like the entire state apparatus is descending on only one person. But as Selom has eloquently said, I've been asking myself, now, we have heard this many times that there are people really who are behind this Galamsey business, okay?
Yeah.
They are faceless people who are destroying the environment, but we never see them. But we hear also that they are highly connected. And Aisha Huang may be, in some connection with some of these people. But as you can see, the proceedings now are all about Aisha Huang and about 3 other Chinese people. And as Salom has said, what would happen? Assuming that Aisha Huang is put in jail, would Galamsey stop? It won't. It means that there are other people who are destroying the environment.
Yeah.
And we have to look out for those people as well.
Yeah.
It's very important. Now, having said that, the issue of deportation, this is how I look at it. The deportation, for me, it's a harsh way of getting you out of the country. You are expelled out of the
short notice.
Yes, on short notice, on the basis of the commission of a crime. Okay, so generally there's a crime underpinning your deportation, or where your being in this territory is no longer desirable, and then you have to take taken out. Now, if you look at repatriation, if you look at the Immigration Act, right, it doesn't define what repatriation is, but it makes references to repatriation. So, for instance, when you are repatriated, the one who is being repatriated, or the one on whose account the person is being repatriated would bear the repatriation expenses.
Okay. When
it comes to deportation, there are expenses, and the one who is being deported, where it's possible, would bear, the deportation expenses and things like that. So it doesn't really define repatriation, but it talks mostly about deportation and gives the conditions for deportation. But if you read the law carefully, you will find out that the repatriation, as used in the Immigration Act, makes references to employment situation. So, for instance, and it's prevalent across the document. So, for instance, you bring in somebody here. So an employer brings a foreign national to work here.
Yeah.
Now you are here to work. Okay. Now, when the period of work succeeds and you are no longer working, the requirement is that those who have brought you here to work must notify the ministry to inform them that this person's business is over, and you have to take steps to make sure that you are repatriated, and that's done in a more dignifying way. You get the point. Yes, as compared to deportation. Deportation is quite harsh, and there's very little time to
they can actually bundle you up in handcuffs and put you on the plane and all that.
And put you on the next available flight and things like that. So that's how I see the difference. And let me say once again that you would find a definition of repatriation in the law. But deportation is talked about quite often, and there are references to repatriation. And repatriation is more dignified, that the government, does it in a way as not to make you look like you are a criminal or you are a lawbreaker. But deportation, it comes across as if you are a lawbreaker, and we've had deportations in this country's history many years ago, and it continues. So if you do not need those characters here, you let them go to their country. But before you do that, you have to treat them with some dignity. It's very important, yes.
Okay.
So
let's wrap it up.
So delving into the matter itself. So we know they are in court on a number of charges. So Aisha Huang especially is being charged with mining without licenses and also engaging in sale and purchase of minerals without licenses. So I have the Minerals and Mining Amendment Act, 2019, Act 995. Where, of course, we've heard the President and the Information Minister say that this is under a new legal regime because certain portions of the parent law itself has been amended, and one of those amended portions or sections will have to do with the offences and penalties. So the penalties have been stiffened, to make it, in the view of the makers of the law, a bit more deterrent for people contemplating
getting into the space
to desist from doing so. So, for example, she's been charged with mining without licenses and engaging in sale and purchase of minerals without licenses. What does the law say about these charges?
Okay.
So a person who buys or sells minerals without a license in accordance with Section 68297 or 104, which is what she's been charged with, commits an offense and is liable on summary conviction to a fine of not less than 10,000 penalty units and not more than 15,000 penalty units. A penalty unit, as it stands now, is 12 cedis. That's one penalty unit. So 10,000 penalty units times 12 will give you, is it 120,000 Ghana cedis? That's a minimum. The maximum will be 150,000 Ghana cedis.
All right.
And the term.
So now, before you continue, we need to take a quick break. We'll come back and then we'll continue with this. Okay. So let's take a short break. Don't go anywhere. We'll be right back. All right, welcome back. It's still a question of law. And Salam was taking us through what the Act says now, the renewed Act says now about the law.
All right, so the charge is that she sold or bought minerals without license. And so the punishment is that once you do so, you commit an offense and you are liable to a summary conviction to a fine of not less than 10,000 penalty units or not more than 15,000 penalty units. And you said a penalty unit is 12 cedis. And to a term of imprisonment of not less than 15 years and not more than 25 years.
Wow.
So you can't be imprisoned for 9 years. You can only be imprisoned between 15 and 25 years. Between 15 and 25 years. So that is what it is. Interestingly, in many other cases, we see and or, but here it is and. So you have to be fined and you have to also do jail time. So that is what we have here.
There's a part of law which says both. If you go down a bit itself,
Yes. So when you look at the other part, that is subsection 3, said a non-Ghanaian, so the other part of the offense she's been slapped with, or the charge she's been slapped with. A non-Ghanaian who undertakes mining operation or facilitates the participation of any, not this one. I think the other offense or the other charge is engaging in sale and purchase of minerals without licensing. So, where a Ghanaian who is liable to summary conviction under so and so, a non-Ghanaian who undertakes a mining operation or facilitates the participation of any person in mining contrary to the provision of an act commits an offense and is liable to a conviction or a fine, term of imprisonment, both fine and imprisonment. I'm trying to just locate the other part.
So before you come, clearly, I mean, there's a new regime. Now, before this new regime, I mean, punishment for indulging in illegal, mining, what we call Ghana would have been a fine. Okay, but now you won't get that. You may have to get a jail term. And you see the seriousness of the jail term, not less than what? 15 years and not more than 25 years. Which means that if Aisha Huang is convicted and sentenced, she could go to jail for within that period. And that's why I'm concerned about making Aisha Huang the center of all this. Look, we have to make sure that in taking her through the criminal process, look, at this point, she's only presumed to be guilty. She's not guilty at this point. And that's why she has a lawyer who's representing her. So the state, I mean, my only admonition to the state is that we give Aisha the fair opportunity to be heard. I'm very sure that in the course of trial, a lot more things will come out that we didn't know before. And I know that Nkrabea Father is an experienced lawyer. I mean, in handling this matter, trust me, when the state takes the box, he may take them through a certain, because see, we have to be able to get all those who are involved in this, and then
important.
and it's very important. Otherwise, we are just scratching the surface of the whole issue. Okay.
All right.
Yes. So
the other part too is that when you are convicted, you will be made to serve the full term. After which you'll be deported. So now we will not have. Of course, the Attorney General can at any time enter what we call the nolle prosequi, which is a facility available to the state to discontinue cases, if he so wishes.
And the president may even grant a pardon if he so wishes.
The president may do that.
Because the Constitution overrides the provision of this law. So,
but given the vibes, as it were, we are getting from the Attorney General and the president, and given what has happened in the immediate past regarding her supposed deportation or repatriation, I'm not sure if any of the two will want to, employ any of those facilities. In fact, the political backlash alone will not allow them. So let's just assume that she will have to go to the full trial, and if she's found guilty, serve the full term. But very important point Albert makes about giving her all that she needs to go through this trial fairly. She is presumed innocent until she's found guilty
in court.
And the difficulty some of us have is the way senior actors of the state have begun asking for the cooperation of the judiciary. The judiciary has always cooperated. So for example, saying that enlisting the support of the judiciary to give her the full extent of the punishment.
You think it's prejudicial?
And my fear is that the weight and overbearing nature of these state actors
and the influence
they bring to bear on their statements may, I'm not saying it will affect the independence of the judiciary, but it is of concern to me that those statements could impact or somehow affect the independence of the judiciary. Though I trust the judiciary to do an independent job. It's the same way when matters are in court. We are advised not to be speaking or talking about those matters because the judiciary doesn't have to be influenced by what we think. They have to be influenced only by the facts and evidence available to them. So that is just something I want to put across.
But of course, you know that this matter is in court, so it's something that we can't delve in too much and deal with that. But in this season, with Aisha Huang's issues going on and everything else, there's also something else that's happening at the same time. SIM card re-registration and legalities or illegalities thereof. NCA has insisted that the telcos do certain re-registrations. The telcos, have obliged, so far, and then public pressure somehow seems to have come to bear, and NCA seems to have backtracked a little bit. Let's get into the legalities of all of this as well.
Kweku, first, before I even talk about the legalities, let me say that when you are a decision maker, you're a policy maker, you're a decision maker, and you are an implementer of decisions, and you take a decision and you continue to backtrack all the time, people lose confidence in the way you do things. And I'm extremely concerned that, and I'm going to say public opinion is very useful. It's one of the key limitations when it comes to excess of government power. Okay, so you have to listen to the people. But consistently, I think that in respect of this SIM card issue, the Ministry of Communication and then its agencies, have been always giving into the public pressure. Well, in one breath, you say that it's good to listen to the people, but in another breath, it's actually taking away the confidence of the people. Now, what it tells us is that people do not think through the decisions they take before they take them.
So when you don't think through decisions, you always backtrack.
You always backtrack.
Okay.
If you don't think through, you always come back to a track. But once you think through, you look at the pros and cons, it's very difficult to shake you, even when the pressure becomes enormous on you. And that's
because you would have anticipated whatever things would have.
And that's the biggest concern. That's why I made that point from the start. Okay. Now we operate in a system of rule of law, and this is not just a mere concept, but it has practical implications. Okay, that before you take a step, there must be predetermined rules, and your acts must be in accordance with those predetermined rules. Now, it is not within the power of any individual in a modern democracy to sit in their offices and say, today I want to do this. without the backing of law.
Okay.
When you begin to do that, that's going to be a recipe for chaos. Because people are also going to begin to take the laws into their own hands.
Yeah.
Because those who must protect and safeguard the law themselves are acting in an arbitrary fashion. And that's what worries me again about this whole Ministry of Communications and NCA. Look, first of all, let me look at this from two levels. When it comes to the use of communication networks, right, there is a regulator. Because of the nature of the commodity, right, you have a state regulator, okay, which has some powers. Now, between the telcos and those who patronize their services, there's a contract between them.
Yeah.
So when I approach a service provider and I decide to use their network, I'm engaging in a contract with the service provider. And that relationship is guided by the terms of the use.
Okay.
Now, sometimes it beats my imagination how the regulator could bring so much pressure to bear on the service provider and ask them to deactivate, numbers which they have received and paid for. And don't forget, these users are using their phones for all kinds of businesses.
Yeah.
And you can imagine the implication of, deactivating people's phone lines. Within the period that this happened, there was a lot of confusion. There was chaos. Businesses had issues and all that.
Yeah.
And so, first of all, apart from saying that the NCA, look, as I sit here now, I do not know of any law which empowers the NCA to ask that people's SIM cards should be deactivated because they have not registered. So I don't know if you have seen any law. Maybe I haven't seen any.
No.
Unless, of course, the NCA is reading some law in a very broad way to give them that power. But otherwise, I don't think that there's any clear power or clear law that gives NPA the power to actually say that I have the authority to disconnect you.
Wow.
Now, even if you wanted to do that, there should be some basis for it.
Yeah.
Okay? And you have to be sure that even if we are asking for a law, right, that law is not inconsistent with the Constitution. Look, I've been thinking, now, is there a right to use phones? I've been asking myself, is there a right to use phones? Now, of all the rights we have in the Constitution, you won't see any right saying that you have a right to use a certain gadget to communicate. But there's a part of the Constitution which says that you have the right to the privacy of your communication. Of course, if you have the right to the privacy of your communication, then it means that you must have a communication tool or gadget.
Yeah.
Which implies that you have a right to own a communication gadget.
Yeah.
So it is for me, it is more of a violation of people's rights in a lot of ways to just make directives which have no basis in law to say that you actually deactivate people's phone lines.
So, what is it, do you think, that made the NCA so confident to act ultra virus?
Well, I think the minister has certain powers. By being a minister, the minister has certain powers to do a few other things. So, for example, there is a LI 2006, which is the specific LI that deals with the registration of SIM, And there is a LI 2111, which is the one on the National Identity Register, which is a regulation for it, 2012. Interestingly, and one of the key issues in this whole discussion has to do with the prerequisite as set by the regulator. You must use the National Identification Card or the Ghana card for the registration. Indeed, there was some registration of SIM some time ago, 10 years ago or so, but maybe that has not been effective, or maybe that has not been foolproof. And so now the requirement by the LI 2111, Section 7 of that, Section 7(1)(L), among the mandatory use of the National Identity Card, we have registration of SIM cards. That, in my view, is a general law. When you look at the law on SIM card, on SIM registration itself, which is the LI 2006, the identity document that you can present to register includes a number of other identification documents, including driver's license, including passport etc. And mind you, all these have biometric, they have provision for the bios or the biometrics of the person. So if the thing is about biometric data, they have it. So is there no way of integrating, or is there no way of merging or transporting the biometric information into the NIA system? Or is there no way of working around it so that the SIM card bearers will not have to go through all of these?
Yeah.
The absurdity in this is that you are punishing me. Meanwhile, the same state which is making the law and trying to enforce a so-called order or directive has not given me the prerequisite the state has set. The state says, get a national ID card, and that is the only document you can use to register or re-register your SIM. As we speak, Ken Atefo has said in many ways, diplomatically, that the NIA has not been set up for this kind of pressure.
Mass registration.
So it appears there's a run on their system. They've not been set up for that. Their law, or they were set up to do a mass registration, which they have done, to set up in all district offices, which they have done, and do a gradual or continuous registration, which they are doing. And its difficulty really is that the nature of the demands on the identity card now is making them appear as if they are not doing their job. But as far as he knows, and as far as his law is concerned, he is delivering, and is delivering at a very high percentage. So now NIA is unable to meet the pressure. So we have millions of cards that have been printed but have not been given out to the people. Anytime you go to their offices, there are hundreds of people queuing there for the cards. A lot of them want to use for the SIM. Others even have other uses for the card. Maybe the SIM is even secondary to them.
I understand that there are cases where there's, I think when he was on CBS recently, he was talking about over 2 million cards that have not been picked up.
And there's shortage of cards as well, the printing cards. There's even shortage of that.
I see.
And so we have people, queuing at the NIA offices, unable to get their cards. The state is unable to provide them the cards.
What it's supposed to
now
provide.
The same state is punishing those people for not having the cards to register.
But let me ask you, so in your reading of the law, have you seen anywhere in the law where the NCA has been empowered, to direct telcos to block SIMs?
No, I've not seen that
precisely
explicitly. What I've seen is that the minister, that's the LI 2006. In the exercise of the power conferred on the minister responsible for communications by Section 97 of the Electronic Communications Act, 2008, Act 775, and acting on the advice of the authority, these regulations are made on this date. Activation of subscriber identity module. One, the network operator or service provider shall not activate a subscriber identity module, a SIM, for a subscriber unless the subscriber completes registration of the SIM in accordance with these regulations and complies with the directives given by the authority under that. So in thinking, maybe we can bundle all of that and put it under this, that because you have not completed the registration, not re-registration, because what we are doing now is a re-registration. If you've not completed the registration, then you will not be activated. So maybe they will take away the activation. But my point is, it's a directive. It's a directive, maybe the minister has issued through the NCA, etc. That directive, maybe what's the fairness in that directive? What's the candor? The people are not getting the thing. It's not their fault that they are not getting. People even have their NIA cards, but they go to register, they tell them the card is invalid. How would they know? And how would they correct it?
How is it their fault?
How is it their fault? And now they have to go back to the NIA. It's not as if there's an office there with somebody when you go there. It's a queue. A lot of people, like stadium. You have to find a way of getting through to get to the place for that to be done for you. Why are you punishing the people for the failure of the state to provide them the document you call a prerequisite for the registration? I have a problem with the LI 211 they are seeking to rely on, because that is a general law. But we have a specific law that deals with SIM registration. And if the principles of the generalis, specialibus, etc. will happen or will kick in, where the courts are more likely to consider specific laws regarding a matter than the general law. This 211, in my view, is a general law because it deals with a lot of other things. The LI 2006 specifically deals with the issues of SIM registration.
Okay.
And it lists other identity documents that you can use. I'm not sure it's been repealed.
Yeah.
And now we are saying that the only document we have to use is the NIA card. No problem. Provide the NIA cards to the people.
Yeah. But
we've not done that.
But using only the NIA card, is that legal?
So
do we have the legal framework
exactly
for that?
the point I'm coming to, I was making.
Yeah.
So the mandatory use of the national identity card, mandatory use, and as one of those mandatory uses in the LI 2002-1111 is registration of SIM cards. The national identity card issued to an individual shall be used for the following transactions where identification is required. So the SIM is part. Look at the wording of it. A national identity card issued to an individual. I have not been issued an identity card. How then do you expect me to use that identity card I do not have for a registration of SIM?
Okay.
For which reason you are seeking to punish me? It does not make sense.
Yes, so there's one thing I don't know. So I thought that there was an extension of the deadline to September.
Yes,
30th.
September 30th.
There was.
So what is the reason why some SIM cards are being
So it was an
interpreted?
arbitrary decision.
So I'm saying that. So that's the point I'm getting to. That there's a lot of arbitrariness surrounding all this. Look, we are cautioned. Those who exercise power are cautioned by the Constitution not to act in a arbitrarily and capricious manner. I mean, you don't do things because you want to cause pain to somebody. Now, as far as I'm concerned, I'm seeing this whole process of deactivating cards as a way of saying that I have the power, and I'll show you where there is power. And that's very unfortunate. And the moment we begin to create such powers, our state is heading for destruction.
Let me just find out
That's the
from you
point.
to wrap up this conversation here. Is there recourse for subscribers to seek redress on this matter?
Of course there is.
Okay.
Of course there is. If you seek to restrict my right to communication or my right to expression or whatever by the use of state power, which is deployed unfairly, whimsically, or in a capricious manner, I have a cause of action.
Okay.
Why is it unfair? It's unfair because you have to give me the identity document
and you
to use. You haven't given me.
You have not
given me the identity document. But here you are punishing me for not going the next step. How do I go to the next step if I've not done the previous step? The previous step is getting the card. Have I tried to get the card? Yes. But do I have the card? No. Is it my fault? No. The system has failed because the system does not have the capacity to take on the numbers to deliver.
Meanwhile, we set a deadline. Let me just add to something. Now, if you look at the Constitution, Article 23, it tells you about administrative justice, administrative powers. Now, it says that administrative bodies and administrative officials shall act fairly and reasonably and comply with the requirements imposed on them by law. And persons aggrieved by the exercise of such acts and decisions shall have the right to seek redress before a court or other tribunal.
And exactly what we are seeing, exactly what
some are bringing up an action,
there's a
right?
class action, brewing. I don't know if they'll still work again with the halting or the backtracking of the NCA and the ministry. You see, we don't need strong people. We need strong institutions, like we've said many times, thanks to Barack Obama. We must ensure that our institutions are strong, and in doing so, we must try to de-empower strong individuals who will see for whatever reason
the institutions work
to push a certain agenda. It's not fair, and in my view, I think sometimes state actors meet or conspire to frustrate the people. That is what it is.
And that's what I'm seeing from this SIM card issue.
All right, okay. Now, I mean, I'm sure we can delve further into this, but in the coming days, we're definitely going to see a lot more of individual subscribers, taking the law route to see what it is they can do to seek redress on these matters. We'll take a quick break, and up next is the docket. Welcome back, and it's time for the docket. This is the segment of the show where we take some of your issues and we look at the legal perspective and give you some legal education. Now, this one says, hello, a question of law. I gave consent to my niece to have my baby's picture taken for a school project. I didn't think anything of it when she asked because she was family. I just gave a verbal consent. Months later, I saw the pictures of my baby splashed all over social media and some news portals and company websites. Imagine my dismay when my husband drew my attention to the fact that our baby's picture had gone viral on the internet. When I confronted my niece, she explained that the project was actually a competition, which was sponsored by another company. And anyone who took part had to give written consent for the assets in the project to be used if they won. I didn't know about this information, and my niece failed to inform me because, according to her, she didn't think she would win. I'm happy that she won the competition, but not at the expense of my baby. We are planning on approaching the company to have the pictures taken down. But since they have written consent and all that, do we stand a chance? Is there a way of seeking legal redress for this issue? How can the law help us? Interesting, isn't it?
Yeah, very, very interesting. So, I don't even know where to start this from. But you see, let me first find, if, as I always say, if I had the parties involved before me, I would ask a few more. It would be easier. I would ask a few more questions. Yeah. But then I have to ask myself, first of all, in what way has the baby's picture been used? Sometimes when the baby's images have been used in a bad way, or in a way that, violates, a number of things, you have concerns, okay? Yeah. I don't know if it's probably an advert or something that they are putting out. We see that all the time. Yeah. But that's not to say that it's right for you to use a child's picture. I think what I always ask when I see situations like this, is there a right? Does somebody have a right in this? Has the right been violated? So what's the right of the parents who feel that their child's image is all over the place and they're not happy with it? Are they concerned that the child is being exposed to risk, which they cannot take and things like that? Now, first, if they have a right, and we can pin that right in law, then they will have a cause of action to enforce that right in a court of law. Maybe when such someone comes, he might be able to identify the right. But I think that in that case, the parents have a right to the privacy of their child. Yeah. The child can't speak for himself or herself. It's only the parents who can act for the interest of the child. Okay, yeah. And the law says that any time things are done, the best interest of the child should be the overriding consideration. So if the parents feel that putting their child out that way really is violative of their rights to privacy and other things, then they might have some rights in the courts, okay, to take on the company and to ask the company to pull down all the images you have splashed all over social media. And so that's how I see it. That's why I said it depends on the way the image has been used. If the image has been used in a bad way, it may have some criminal implications, or there may be some implications in crime also. Yeah. And those are all options. But as far as I see it immediately, I think there's a violation of the right to privacy. And once there's a violation of a right like this, you can go to the court to ask the court to enforce, the rights of the child. Yeah.
Quickly, your thoughts on that?
It's quite, good one there, Albert, but it's quite tricky in the sense that there's been some consent given supposedly by somebody who may describe as a guardian of the child in this case. It doesn't mean if the consent is given and the picture or the thing is put to a bad use, you can't revoke that consent, etc. So it's important to know what is being used for. But I'm just thinking that maybe it's a competition, an advert of a kind. Yeah. We must be mindful of how we put kids' pictures out there. It's not the very best. But in this case, I'm not sure it's been put to a bad use. But there's consent given. So as far as the company is concerned, there's some
permission to do
agreement or
this.
contract between
Yeah.
the participant in the competition with
Yeah.
the niece
Yeah.
or the guardian of the child and the company.
Yeah.
So now third persons, even though the parents, but third person to the contract or the agreement, coming in to say that they should pull down the pictures
Yeah.
will be quite problematic if they are not standing on very good grounds. There will be a breach, and if there's a breach, most often there will be damages and things like that. So I'm not sure it's very straightforward.
Yeah.
We must know exactly what use the pictures have been put and understand the context properly. But it will be quite tricky because there's consent given.
Yeah.
And they don't do these things without having you write. And in this case, we are told there's a written consent. And they also gave consent
Yeah,
to the niece
yeah.
for the picture to be used.
Yeah.
If the niece failed to disclose to you
The details
the
and
details, I mean,
ramifications.
deal with your niece.
Yeah.
You know, I think it's tricky.
Yeah.
I think it
We
can't
may-
go through. It's quite tricky.
Yeah, and we may also come to the point that the consent between the niece and the
parents.
the parents, right? I mean, can it even pass for a proper consent?
Well, she said she gave
with the
verbal
intention
consent,
with the
so-
intention that it's legally binding. Don't forget that it's a domestic setting.
Yeah,
Now,
that's
when
true.
agreements are made in domestic setting, the courts really do not. The courts are not. In hurry to enforce those kinds of agreements, and so I mean
Yeah, so-
it's a complex
It's
scenario.
So the
It's
court
not
in this case,
the
we have
case
to
of-
look at the intention to create legal relations.
relations. Yes.
So what did the girl say? She said she was going to use it for
Something.
for a project.
A project. yes,
project.
school
And a project could
A school
mean
project,
anything.
yeah.
Could be
So
anything.
I think I would blame the niece more than the company.
company.
Because the niece maybe did not
Disclose everything, all the
fully
details,
everything to the people.
Yeah.
So she should actually deal with her niece.
And maybe the company should have also found out more because you see, if you bring a child, whose child is it? Do you have the parents' consent? Is there any form of evidence to show that? Because in that scenario, what happens is that once
So maybe the niece should have provided proof of consent
from
the parents of the baby.
if the company inquired that from the parents. So it's not really
Okay,
it's not straightforward.
fantastic. So I think you should get yourself a lawyer and seek legal advice. All right, well, we'll take a look at our legal trivia today.
Legal trivia. Did you know that where a person loses functionality of his or her genital organs through an accident in the course of employment, such an employee shall be entitled to compensation of up to 85% of a sum of money equal to 96 months of earnings? This can be found in Section 8 of the Workmen Compensation Act 1987, PNDC Law 187. That will be all for our legal trivia today.
All right, thank you once again for watching another episode of A Question of Law. It's been a rather riveting episode this time around. I want to say a big thank you to Selam Adonu, who is a private legal practitioner. Thank you, Selam. And also to Albert Kwashiga, who's also a private legal practitioner as well as a law lecturer at the School of Law, UPSA. Keep watching Citi TV. My name is David Kwekusechi. See you next time.